Hello, good day, sir. I am Roque Jun Kenneth from Section Bravo. First is negotiation versus mediation. In negotiation, the agreement is based on parties' own terms, while in mediation, the mediator attempts to work out on the settlement or agreement that both parties accept or reject. Next is the mediation versus conciliation. In mediation, the mediator will, at most cases, and as a matter of principle, refrain from refrain from making such proposal, while in conciliation, the conciliator will be asked by the parties to provide them non-binding settlement proposal. Next table is the court annex mediation versus court referred mediation versus judicial dispute resolution. In court annex mediation, there is no pre-existing agreement present, but parties were still directed to mediation to declare court dockets. Next is court referred mediation. It is expressly stated in the agreement that in the agreement to resort an arbitration before filing a case in court, while the judicial dispute resolution is that the judge tries to settle the dispute of cases that are not successfully settled in court annex mediation. Next is the arbitration versus mediation versus conciliation. As to its objectives, in the arbitration is the award, and then in the mediation is the settlement, and then the conciliation is the advice to either parties. And then as to the outcome, in the arbitration is the award, and then the mediation and the conciliation is it's either settlement or no settlement. And then as to legality, in the arbitration it's legally binding, while in the mediation and conciliation it's not legally binding. And then how it is being done: in the arbitration, the parties submit their case to the neutral third party, and the arbitrator determines solutions, while in the mediation the mediator determines alternatives, and the parties reach out an agreement, while in the conciliation while in conciliation the neutral third party gives advice, and the parties reach out an agreement. And lastly, the arbitration versus litigation. So in the arbitration it is private and confidential, while in the litigation it is in public. And then the arbitration, the parties can have the opportunity to agree on the arbitrator, while in the litigation the parties cannot agree on the presiding judge because judge is ruffled. Next is that the parties can select a governing law that will determine their substantive rights, while in the litigation the Philippine law governs unless there is a choice of law stipulation in the contract. Next is that In the arbitration procedure is depends on the agreement, while the litigation court of rules of court shall apply. And in the last table is still the arbitration versus litigation. The formal offer of evidence in arbitration is generally submitted at the beginning, while in litigation the formal offer of evidence is only submitted at the end. And then in the arbitration, the venue the venue of arbitration, the parties shall determine the venue, while in the litigation, as a rule, the rules of court shall determine the venue, but it may also be based on agreement. And then the arbitration, the submission to the process in the arbitration is consensual, while in litigation the submission to the process is not consensual. And then in the arbitration, it is called claimant versus respondent, while in the litigation it is either called the plaintiff versus defendant or petitioner versus respondent. And then in the arbitration, the neutral third party is called arbitrator, while in the litigation is the judge. And then in the arbitration there is a stenographer, while in the litigation there is a court reporter. And the award of arbitration might also be called the final award or interim award, while in the litigation the judgment might also be called final judgment or interlocutory judgment. Thank you.